You invented it, but what if someone copies it? Are you protected? That's where patent law comes in. Let us discuss it in this video.
You know that feeling when you get an idea, a really, really good one, and you're almost afraid to say it out loud? An idea that could maybe even change an industry? Well, this is all about how you take that little spark and turn it into something real, something protected. We're going to go on the inventor's journey and figure out the true power of a patent.
So maybe you're that person tinkering in the garage or sketching in a notebook, or you just had one of those aha moments that could actually solve a real problem. You've got it, that brilliant invention. The big question is, now what?
I mean, just think about the huge innovations that are literally changing our world. Things like self-driving cars, the mind-blowing CRISPR gene editing technology, or even a more efficient solar panel. You know what they all have in common? Yep, they all started as brilliant ideas, and now they're all protected by patents.
Okay, so you've got the idea, you can see the potential, but how do you stop somebody else from just swooping in, taking it, and making money off of your hard work? How do you protect your genius? Well, the answer, in a word, is a patent.
All right, let's dive right in. First step on our journey, what in the world is a patent really? And what's it supposed to do?
At its core, a patent is an exclusive right. Think of it like a legal shield for your idea. It's the government officially saying, hey, you came up with this, so for a while, you and only you have the right to make it, use it, and sell it. It's your reward for being innovative.
But here's the thing, it's not a one-way street. The whole system is really a clever bargain. Part 1, you get rewarded and protected for your invention. But Part 2, in return, you have to publicly share how your invention works. That way, other people can learn from it and come up with even more new ideas. And finally, when your patent runs out, the idea belongs to everyone. It's a win-win.
So, just because you want a patent doesn't mean you'll get one. Oh no, your invention has to go through a series of tough tests. It has to run the gauntlet, you could say, to prove it's actually worthy of being protected. Let's see what those tests are.
All right, here are the 3 big hurdles every inventor needs to clear. First, your idea has to be new. Second, it has to involve an inventive step. And third, it has to have some kind of practical use. So just remember that checklist. Is it new? Is it non-obvious? And can it be used? Let's break each of those down.
First up, novelty. This one's pretty straightforward, actually. Your invention can't already exist out there in the world. Anything that's been published, sold, or even just presented to the public, anywhere on the planet, is what's called prior art. Your idea has to be genuinely, truly new.
But wait, what if you're the one who already talked about it? Let's say an inventor named Yasha creates a cool new water pump, and, in his excitement, he sells a few to his neighbors before he files a patent. Did he just blow his chance? Not exactly. The law gives you a 12-month grace period after your own disclosure to get your application in, and that's exactly how Yasha was still able to get his patent.
Okay, hurdle number 2 is the inventive step. Now, this one's a little more subjective. It asks, would your invention be obvious to someone who's an expert in that field? For example, making a spoon that's just a little bit bigger probably isn't an inventive step. It has to be a real leap in thinking, something that wouldn't just be the next logical step for an expert. And this brings us to a really important line in the sand. You can patent a technical solution to a problem, a new gadget, a new process, that kind of thing. But you can't patent abstract ideas. Einstein couldn't patent E=mc² because it's a scientific theory. You can't patent gravity. Patents are for the practical application of ideas, not the ideas themselves.
All right, so your idea made it. It's new, it's inventive, and it's useful. You're all set, right? Not so fast, because now the race begins. And in the world of patents, it's not about who thought of it first. It's about who gets to the patent office first. This story is just a brutal, perfect example of why that race is so important. So Cesar is the true inventor, no doubt about it. But his co-worker, Francis, sees it and immediately files a patent application. Cesar, the actual inventor, waits 18 months to file his. And by then, it's too late. Under the first-to-file rule, Francis gets the patent. The lesson is painfully clear. Do not wait.
Now, things can also get tricky if you invent something at work. The general rule is simple. The inventor owns the patent. But if your job is literally to invent things, then your employer probably owns it. Here's the kicker, though. If it's not part of your normal job, then you own it, even if you used company resources to create it. Okay, you did it. You ran the gauntlet, you won the race, and you have the patent in your hand. So what now? What kind of superpowers does this piece of paper actually give you? Let's talk about your rights. And of course, the fine print. First up, let's talk about the clock. Your exclusive rights last for 20 years. And here's a key detail. That 20-year clock starts ticking from the day you filed your application, not the day it was officially granted. And once those 20 years are up, that's it. Your invention enters the public domain for everyone to use.
So what can you do during those 20 years? Basically, you're the king of the castle. You have the sole exclusive right to stop anyone, and I mean anyone, from making, using, selling, or even importing your invention without your say-so. It's your monopoly.
But, and this is a big but, that power isn't absolute. There are some important exceptions. For instance, someone can use your invention for their own private non-commercial use, or for scientific experiments and education. The law is trying to strike a balance between protecting you and letting society learn and grow.
And now we've reached the final stage of the journey. And honestly, this might be the most critical part. You have your patent, you're on top of the world, and then you see it. Someone is selling a product that looks awfully familiar. It's time to defend your idea.
So, when you take someone to court, how do they decide if your patent was actually copied? Well, they've got two main tests. The first one is easy. It's called literal infringement. Does the other guy's product match the exact description in your patent, word for word? But what about clever copycats who change a tiny little thing? That's where the doctrine of equivalence comes in. It asks, does it do the same thing in the same way to get the same result?
And this quote from a court case nails why that second test is so important. It says that if people could get away with imitation just by changing a tiny detail, then getting a patent would be a hollow and useless thing. It makes sure your protection actually means something.
And if you win your case, oh yeah, the law has your back, and it has some serious teeth. You can get money to cover your damages and legal fees. You can get a court order, called an injunction, to make them stop immediately. And get this, in some cases, the court can make them pay you up to 3 times the actual damages.
And so we come full circle. The inventor's journey is complete. From that first little spark of an idea, through that tough gauntlet, winning the race to the patent office, and now knowing how to defend it. You've done the work. You've secured your rights. The patent protects the idea. So the only question left is, what are you going to build with it?